All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is number 220910, guardianship of Faircloth versus Main Street Entertainment.
Good morning, and may it please the court, I'm David Sales, here with Daniel Hoffman for the petitioner. The court should answer the question certified by the district court by addressing the issue in the same manner that the trial court did. That is to say, to consider whether the comparative fault statute covers this action because it is a negligence action as defined by the statute, and alternatively or additionally to consider whether this action is excluded from coverage of the comparative fault statute because it is an intentional tort. Doing so, and in the process considering the substance of the action, should lead the court to the same conclusion reached by the trial court, that this is not a negligence action as defined by the comparative fault statute, and that it is, or alternatively, because it is an intentional tort action. On the first question, I would like to suggest to the court that there are 4 logical steps to reach the conclusion that this is not a negligence action. It cannot be denied, and this is the first step, that this is a willful tort. Liability under section 768.125 is dependent upon proof that selling to a minor was done willfully and unlawfully. This is a willful tort that should not...
One thing doesn't necessarily require the other, right? I can willfully commit an action in a concatenation of actions that leads to a tort that sounds in negligence. You'd agree to that, right?
I think that is true.
So
willfully and unlawfully, sorry, go ahead.
So distinguish that general rule from what you're arguing. You know, if I make a purposeful decision to leave a box near a train and turn my back on it, and it winds up being too close to the train, it hits it. I mean, we've got sort of the classic definition of negligence. So I think you've abbreviated in your argument the gap between the willful action and whether or not the cause of action sounds in negligence or an intentional tort. Can you make the connective tissue for me?
Willfully and unlawfully, which is the...
Oh, so the rule you would espouse is if the willful action is unlawful, then it can never be negligence. Then it has to be an intentional tort.
No.
Well, then help me understand your rule.
The question of willfulness is a question of textual interpretation, first of all. And willfulness has a particular meaning, which this court has recognized for a long period of time, which means intentional conduct of a sort. And I understand Your Honor's question. When one acts both willfully and unlawfully, one has acted in a way which reflects a conscious disregard of the requirements, a contumacious disregard of the law's requirements. And the question, if you're really focusing on whether it's intentional tort or negligence, which causes this case to be placed at the spectrum close to, or if not at the end toward intent, is the desired consequence, because it is substantially certain. If something is an intentional tort, I think everyone should be able to agree. If it's excluded, it's not included.
There's another sort of layer to this, which is you could describe as willful or contumacious the decision to, say, sell a drug, right, an illegal narcotic. We would say that that act of sale constitutes a crime. But if the person that I have sold the drug to gets behind the wheel of a car and gets into a car accident, am I, in addition to being a criminal, guilty of an intentional tort? Is that the rule?
No, I think the question depends on where you draw the line at harm. Our position is, because, to use Your Honor's example, it is also a crime to possess the narcotics, the dealer who sells the narcotics obviously intends for at least possession, and they intend to cause, at least according to the legislature's conception of what's harmful to society, some kind of harm, because we should all be able to agree that it is harmful not only to sell narcotics.
But that would apply to any per se tort, a claim of per se negligence, it seems to me, based on a statutory violation. Because whenever there's a statutory violation, somebody's done something unlawful, they violated a requirement of the statute, and it just seems like what you're arguing would be so broad.
But the legislature here has not, since 1980, has not rendered this tortious conduct because it being a violation of the statute. I know some of the cases talk about that, but we don't need to look away from the text of Section 68-125 to discern what the elements are. And one of the elements is willful/intentional misconduct.
But the point is that there would be other instances of per se negligence that would involve the same sort of violation of a statutory requirement, and sometimes the statute might have an element of willfulness in it. Right. But that doesn't mean it's not per se negligence with respect to a person that is injured as a consequence of the violation.
And I think that's why this comparative fault statute requires that we examine the substance of the particular tort in question and determine, remember, that the legislature has defined what a negligence action is. And this action does not meet the definition of what the legislature has determined as a negligence action.
Well, it sure looks a lot like a per se negligence theory here that the legislature has enacted.
Well, very few people, I would submit, would agree that the sale of 24 alcoholic beverages to a minor over a course.
But counsel, you're focusing on the particulars of this case, which may be egregious. Put that aside. But we don't interpret the statute based on the egregious facts of a particular case. We've got to look at the statute in its general application. Isn't that right?
I think the answer to your question is actually you do both. If you take the example of the Petty Doe case that's cited by the defendant, what the 4th District did was look at the particular facts of the case and say it's a close call. Now, those were undisputed facts. And in my response to your last question, I was merely urging the court to take a look at the facts here that are undisputed. And in that instance, it can be determined, according to that case, which both parties have relied on, it can be determined as a matter of law and should be determined as a matter of law based on undisputed facts. Here, this is exactly the kind of situation that the statute is meant to cover, we would submit. And our position is that if it doesn't meet the definition of a negligence action, as the legislature has described it, and remember, as Your Honors heard quite frequently yesterday, the comparative fault statute, like other statutes, did not displace the common law unless it did so with clarity. And at common law, Your Honor's question notwithstanding, willful torts were not subject to contributory fault. And why should there be a difference here? Where in the statute, is my question to my colleague and friend, where in this statute, in the comparative fault statute, does it indicate that a willful tort is subject to comparative fault analysis? It's nowhere to be found.
I'm sorry to interrupt you. So part of this, though, is I think gets to how you're characterizing 768-125, which I think that our court has been pretty consistent that it doesn't create a cause of action, it's a limitation on liability. So why isn't the right way to look at this to say that you have an underlying negligence per se action where the duty that allegedly is being breached is defined by the statute? That duty can be breached in terms of the statute itself, doesn't have a mens rea requirement, and so it could be a strict liability thing. Hold on.
Sorry.
And the legislature is basically saying that within the universe of violations, the only ones that could subject you to tort liability are ones where you knowingly sold the alcohol, which really is kind of important to bring it into kind of the negligence framework in the first place, because that's what makes the risk that you've created foreseeable, et cetera, et cetera. So why isn't that the
I
right
disagree
way to
with
look
Your
at
Honor
it?
for the following reasons. First, I think the trilogy of the cases that I believe Your Honor is speaking about, which are Armstrong, Migliore, and Ellis, what they say to me is that a negligence cause of action has been abolished by the legislature in this setting, at least in this setting, certainly, with respect to the willful and unlawful sale of alcohol to a minor. That's exactly what the 5th District said in the Austin case. If we had, in fact, as in Austin, brought a negligence claim in this case, a common law negligence claim, it should have been dismissed, or summary judgment should have been entered against us, because those cases, and Austin says this as well, teach that negligence and negligence per se, I know there's a lot of discussion about it in the cases, but if you look at them together and certainly consider Austin, negligence and negligence per se claims sounding in negligence have effectively been abolished because the court restored the common law rule except in the exceptions that are stated. And when it did that, it elevated the standard that plaintiffs are subject to in order to impose liability on a defendant, with, again, the focus being on the sale and not on the consumption. And the point simply being, it's not only a matter of text. When you look at the statute, the comparative fault statute, you can't find a place to fit this particular cause of action. I understand that the court has repeatedly said that there was no creation of a cause of action. I think that has led to some confusion in the cases, but at least one should be able to, all should be able to agree, as the 5th District said in the Luque case, that's L-U-Q-U-E, that if the cause of action was not created by the legislature, at least the legislature has defined a cause of action.
I'm sorry, go ahead.
Go ahead.
Doesn't Thornburg require more?
In what sense?
I mean, that's sort of like overruling the common law by negative implication. Doesn't Thornburg require 768125 to say something it doesn't say in order to achieve the outcome you're talking about?
I'm reading now from the decision in People's Gas. Statutes will, this is 332 Southern 3rd at 611, statutes will not be interpreted as changing the common law unless they affect the change with clarity. And the court also said at the same page, a basic rule of textual interpretation. This is a basic rule of textual interpretation. And actually, this court has applied that rule in construing the comparative fault statute twice, once in the Merrill Crossings case and once in the Sheff case. So I would disagree with Your Honor that there is a requirement beyond what was just stated here. There's no indication in the comparative fault statute that it applies to intentional torts, and in fact,
But
they were
this is
excluded.
not, I mean, but this gets back to I know there's kind of a fine line between the first part of your argument and your argument that this is an intentional tort. But, I mean, at the end of the day, the theory of your case is that by intentionally selling alcohol to a minor, the bar here created a risk of harm, which unfortunately, tragically, eventually resulted in this accident. I don't think that there's any allegation that the bar, wanted that consequence to occur or was substantially certain that it would occur. And that's, that's sort of the very fundamental dividing line between negligence actions and intent-based actions.
Well, my opponent makes something of the fact that we don't allege that, but where does the law require that when one is pursuing an action that falls outside of the comparative fault statute or is properly, as we say, classified as an intentional tort, where does the law say you have to say that? And we gave the example of this court's approved cause of action for conversion, an intentional tort, which doesn't require that a plaintiff say any of those things.
No, but the statute says that it's the substance that controls, right? And what I'm asking you is, why isn't the substance here the creation of a risk that tragically actually led to a harm? As you know, I mean, you can sell alcohol to a minor and nothing happens, but unfortunately, this consequence did happen. But it wasn't intended.
Well, we believe that there was an intent that some consequence would follow. There's an intent, at least, that consumption will follow. And I think it's important to remember, that there is no liability. The cause of action doesn't exist unless there's intoxication. If I slap Mr. Hoffman with my hand, the tort is not complete until my hand touches his face.
But you just said it's the focus is on the sale. It's the willful intentional sale.
The focus is on the sale because there was a historical reason for the legislature to focus on
Textually,
the
though,
sale.
the focus is also on the sale, though, correct?
The focus is on the sale, but the sale can obviously be intentional. I don't think the court is having any difficulty with that. The question for intentional tort purposes is, does the seller intend any, or is it substantially certain that any consequence will follow? Who doesn't think that there will be substantially certain?
And why are we looking at substantially certain for that to follow? I mean, why doesn't it not, based on the text of the statute, fall into strict liability or negligence per se? We're focused on the action, we're focused on the sale, we're focused on the manufacturer, we're focused on breaking like a construction rule.
Right. None of those things are to be found in this case. I was responding to a question sort of pushed into the intentional tort side of the analysis. But I agree conceptually that there's nothing in the comparative fault statute that would suggest that this is anything like any of those causes of action. My opponent says...
I guess that's why is it not like that, though? Because here the focus in the statute is on the sale, as you highlighted. So it's the willfully and intentionally is connected to the sale to the minor. Do we know that this person is a minor? Did you intentionally sell to a minor? It's all connected to the sale to the minor. The statute leaves open the consequences of that. I think you're mapping on an additional willfulness requirement connected to the injury that's not textually supported. So I'm wondering why, when the text connects willfulness to the sale, it's not more like a strict liability or negligence per se
Well,
action.
in the example that I was just giving, the willfulness is the motion, the voluntary motion of my hand. I may or may not cause an injury that's compensable, but I certainly intend to do the thing that results in the injury if there is a compensable injury. And here I think the issue is the same. We have urged the court to consider, because this tort is a tort for causing intoxication, something that is clear from the text of the statute and the title of the statute, that once the tort is complete, there's no more question to be asked about whether the consequence is substantially certain to follow, because it is in fact a fait accompli, just as when I have struck Mr. Hoffman with my hand in the case of a battery. So for those...
In every case in which there's a sale, there's going to be some sort of tragic
No, and I think we say quite clearly in our brief, there is no requirement that there be catastrophic consequences for this to be classified as something that is non-negligence or an intentional tort. There has to be only a consequence that's substantially certain to occur. And if one serves to the point of intoxication, which is the minimum threshold for entering the courthouse door, pursuing this cause of action, there is a consequence. Everyone should be able to agree, at least it's the legislature's policy in this state, that minors shouldn't drink at all since 1935, and it certainly should be the policy, is the policy of this state, that they should not be intoxicated. That's why there's a consequence for the bar who acts willfully and unlawfully. I'd like to spend a couple more minutes talking about the issue of intent with respect to this particular cause of action. And going back to what Justice Kennedy was asking me a few moments ago, I do believe that if the court does not believe that this is a cause of action as a matter of law, which sounds an intentional tort, that the court can and is in fact obliged to consider the undisputed facts. That is something as a matter of law in the Petty Doe case that the court should consider in deciding whether or not this is an intentional tort. I want to touch very briefly on the alcohol statute. I see my time is dwindling. And urge the court also to take up that issue and hold that section 768.36 does not apply in this case, because it imposes a requirement that there be a fault-based comparison of some kind in order to have the statute apply.
I'm sorry to interrupt you, but let me ask you a quick question about that. I know the other side says that that statute can apply even in the context of intentional torts, but do you agree that if we conclude that this is a negligence action, that pretty much resolves the alcohol defense
Before
issue?
Mr. Hoffman went to bed last night, he asked me that very question. What would I say in response to that? And my answer is that I would be obliged to concede that if this is a negligence action as defined by the comparative fault statute, then the court, because the statute should be read in peri materia, should rule that the statute applies. I think it would be unreasonable and irrational and actually contrary to the First District's conception of the way the statute should operate, certainly in what I call a one-bar case. I don't know how much time Your Honor is going to
You can wrap up, and we'll give you 3 minutes for rebuttal.
3 minutes for rebuttal. So I will reserve the rest of my time then for rebuttal on that. Thank you, Your Honor.
Thanks.
I need about 5 minutes to lower the podium. May it please the court, Raul Cantero, along with my colleague Veronica Gordon, for Main Street Entertainment, doing business as Potbellies. I want to begin with Justice Curiel's first point and question. An intentional act need not be an intentional tort. An intentional act is often a willful act, but it doesn't intend injury, nor is it substantially certain to result in injury or death. This court in DeMario defined what an intentional tort is, and that part of the opinion has not been abrogated by statute, as a deliberate intent to injure, or a person shows a deliberate intent to injure or engages in conduct which is substantially certain to result in injury or death.
I have a hesitation about a rule that essentially winds up washing out the fact that the recipients of the alcohol, the purchasers, if it was purchasing, it was part of their compensation package, were minors. So it seems to me that if the facts were identical, except for the fact that the employee was of drinking age, it seems to me that you would still be urging the same rule, wouldn't you?
In terms of intentional versus yes.
Okay.
Yes.
So doesn't it seem odd to you that that fact is of no moment? The fact that they were arguably committing a criminal act, certainly committing a willful violation of the statute in not just serving alcohol to minors, but they presumably have W-2s for these people. They know that this barkeep is underage, and yet he gets a 50% discount for alcohol. I mean, it sounds like a recipe for disaster, and yet the rule you're advocating sort of wipes that all away.
I disagree, Your Honor. The rule I'm advocating is that this is negligence. It's a negligence cause of action. They would still be responsible if the person became intoxicated and to the extent that intoxication resulted in injury or damage. So they're still responsible. This is not about whether they're absolved of any liability. It's about whether this is a negligence action or not. And if it's a negligence action, is fault apportioned with other actors that may have committed the same thing, other bars that may have done the same thing to other people, which resulted in a tragic accident. So it's not designed to absolve.
Can I ask you about the decision below, and in your briefs, you kind of adopt this idea that this is a derivative tort. And there's two aspects to that. One is that there has to be the kind of the tort committed by the bar. Then there has to be a subsequent tort, which I think is, obvious. But the second part of it that says that then the bar becomes liable for 100% of the fault of the patron. It seems like the support for that is really thin. And I want to make sure that however the court addresses this issue, that we don't kind of unwittingly sort of cut off litigation later on as to the role of the fault of the actual recipient here. Because, this is a case where the harm that we're worried about is to a third party. But, if the person harmed had been Dwyer and he sued the bar, am I right that under the logic of how you characterize the derivative tort, that essentially there would be no assignment of comparative fault to Dwyer?
Yes, Your Honor.
Okay. And so in that sense, we would be saying that the comparative fault statute doesn't apply to this, right?
Right.
And so that sort of gets to, the phrasing of the certified question and all that. Could you address that?
Yes, Your Honor. I know exactly what you're talking about. At trial, that was the position we took, is the position we're taking now. So
I know it's kind of
I felt like I could not argue what you're saying now, but I will point out that other cases have apportioned fault to the minor. I'm specifically thinking of Tuttle versus the Miami Dolphins, where the jury ascribed 45% fault to the minor. And so I don't think courts are uniform in how they interpret the statute, and it's certainly a logical interpretation that once you have comparative fault, and if the recipient of alcohol is at fault, that some fault should be ascribed to that recipient.
So in this case, we're kind of, and I'm not saying that I have a problem with this, but because of the way it's been litigated, we're sort of locked into the view that we're really comparing to, whether you call it the bar in Dwyer or the other bar in Faircloth, it's two, but really the statute would tell you that there's four different faults to be apportioned.
I kind of disagree with your conclusion. I don't think you're boxed into anything.
Well, but I mean,
I was boxed in.
No, but I mean,
I was boxed in. You're not boxed in.
no, but I mean, nobody here has I think that they've challenged the mandate on the basis of getting the intent part wrong. But I mean, I think everybody has sort of accepted that if it's going to go back, that the mandate that the first DCA settled on is how it would be.
Yeah, that's the way it had been litigated, yeah, right. But certainly the statute can be read in a different way, and logically speaking, if you're looking at one thing that we can derive from the alcohol statute, 768-36, that was adopted in 1999, is that there is a trend all the way from 1980, 1986, 1999, and continuing to assign liability and the extent of liability depending on the fault of the particular parties involved, and not have the fault always assigned solely to the defendant. But
yeah, I mean, it's a tough policy question because on the one hand, the whole duty here is to sort of protect people from their own bad behavior. On the other hand, why would we, in the absence of statutory directive, why would we adopt a rule that tells a 20-year-old you can buy this stuff illegally, get drunk, cause an accident, and you have zero responsibility for that yourself?
Hence that alcohol statute. That's why I think that was adopted, is to start putting some responsibility on everybody, not just on the people serving the alcohol, but on the people consuming the alcohol, because a lot of times because of the way 768-125 is written, it has to be a willful sale, and courts haven't uniformly interpreted that as a knowing sale, meaning you know that the person is a minor. A lot of times they don't know that the person is a minor. Sometimes a minor uses a fake driver's license, and the defendant is not going to be liable. The minors need to understand that there's some responsibility on them not to violate the law themselves in order to obtain alcohol, and that's what I think the amendment in 1999 tried to emphasize. I wanted to go back to the intentional versus negligent. I read out the definition of substantially certain to result in death. The plaintiff conceded in its initial brief on page 52, and I'm going to quote, "To be sure, it is not substantially certain that willfully and unlawfully serving a minor to the point of intoxication will lead to further injury of the minor or third parties, or third-party injuries." So they have conceded that this is not an intentional tort because they don't offer any alternative definition of an intentional tort. All they say is, well, this is intentional because it was a willful.
Then they kind of take that back a couple pages
They try to take it back, but let's let them take it back. They never alleged.
Well, to your point of us not being boxed in, why isn't, if the natural outcome of willfully and intentionally selling alcohol is intoxication, and nothing good can come from that, well, how does that not fit within the substantially certain framework?
Because it creates a foreseeable risk. Nobody disputes that serving alcohol to a minor creates a foreseeable risk of injury. But even this court in D'Amario said that driving under the influence of alcohol itself is not substantially certain to result in injury. You said that in D'Amario. But it does create a foreseeable risk, hence it's a negligence action. Unless the court has any other questions on on 768-125, I think our position is clear. The courts have interpreted the word willfully as knowing, a knowing sale, and as Justice Sasso said in the text, knowing, willful is next to sale. It is not next to anything else. So it's the sale that needs to be willful. We've cited some cases that show that a intentional act, a willful act, is not necessarily an intentional tort. We cited the Spivey case from this court in 1972, in which a friend grabbed another friend by the neck and, lo and behold, paralyzed the left side of his face. And the court said, well, the act of grabbing, sure, was intentional, but he certainly didn't intend the result of paralysis on the left side of his face. And so that's not an intentional tort.
Well, I'm assuming if willful meant something more than intentional, you wouldn't have stipulated to that. I mean, you wouldn't have stipulated that you deliberately sold alcohol intending that someone be harmed.
Correct.
In this way by it. I mean,
that's right. That's the only reason that we stipulated. We also cited, as Mr. Sales pointed out, the Petit Doe case from the 4th DCA. In that case, it didn't concern this statute, but it did concern the difference between an intentional tort and negligence. And in that case, the driver was fleeing the police. There was a school bus that had stopped to let out a student who happened to be deaf, put out you know how the stop signs come out of the school bus when it stopped. The driver fleeing the police ran through, speeding, and hit the student who happened to be deaf and didn't hear the bus driver honking. And in that case, the 4th DCA said, well, that's tragic and it's negligent, but it's not an intentional tort. Certainly the driver intended to go 55 miles an hour, intended to disregard the stop sign of the school bus, but did not intend the injury. And I would also analogize it to something much more common in daily life, running a red light. Somebody runs a red light. They know the light is red, but you know what? It just turned red. I wish it'd still be yellow, but I'm going to run that anyway because I need to get somewhere. They take the red light willfully, deliberately take the red light. An accident occurs. Somebody gets hurt. The driver who took the red light did not intend that accident, and it wasn't substantially certain to occur, but there was a foreseeable risk. So it's negligent that the person took the stop sign, even though it is negligence per se to violate the statute, which requires you to stop at a red light. That is not an intentional tort. It is an intentional act. So that's the difference in the statute. In terms of the alcohol defense, we call it 768.36. I think, Chief Justice, you are correct, and Mr. Sales has acknowledged that if you hold that this is that 768.125 defines or limits a negligence action, it's not an intentional tort, then all the dominoes start falling. There's comparative negligence, and 768.36 applies. If this court does not rule that way, then it certainly needs to determine the issue of 768.36. We submit that statute is very clear. It says in any civil action. In any civil action means in any civil action. It doesn't mean in any negligence action. It's not limited in any way like some of the statutes that the plaintiff has cited. And I will point as analogous 768.72, which is the punitive damages statute, which also applies in any civil action. Nobody has held that means that it applies either only in negligence actions or only for intentional torts. It applies in any civil action. And so we submit that any civil action should be interpreted the same way in 768.36. And I submit that the court should approve the decision of the first DCA. Thank you very much.
Justice Sasso, in response to the question that you asked Mr. Quintero, this is the note that I have. Potbellies will not accept that the intoxication of minors is inherently harmful, but the legislature of this and every state in the nation disagrees. The tort is not complete. It doesn't occur unless there's intoxication, and the substantial certainty test is met by virtue of the elements of the tort being proven.
But
Just-
not every minor who is unlawfully served, who gets drunk, is going to have a claim under this statute.
Well, they only have a claim if they cause
Well, I
harm,
understand,
actionable harm.
But it sounds like you're saying they've got a claim once they get drunk. But that's not the way this works.
I would disagree only to the extent that the statute, if the elements of the statute are met and proof of willful and unlawful sales is obtained.
There's got to be injury or damage
Right,
caused
well,
resulting from
I've never taken the position that everybody has a cause of action if they get drunk. There has to be resulting damage. That's the two-tiered levels of causation that are addressed by the parties in the brief. But this wasn't running a red light. And the example that was given about a bear hug that doesn't result in any damage, there's nothing like that here. And Chief Justice Muniz, I want to respond because you said you stipulated this because of X, Y, and Z, and you couldn't possibly have intended thus and so. What really happened, and I don't think Mr. Quintero was there, but what really happened was the trial judge, Judge Carroll, may he rest in peace, was poised to admit evidence that they do this every night. And they stipulated to avoid and obtained a favorable ruling that kept out other incidents of doing the same thing over and over again. And that is something that should inform the court's decision-making with respect to this. They stipulated that they willfully and unlawfully sold because he was the employee. They had no choice.
Right. The point, though, is that in this context, the word willful means intentional. They knowingly sold to a minor, or they knowingly sold to 500 minors.
But the
I mean,
law,
that's the point. The point is the knowing of the sale to a minor as distinguished from knowing or intending that harm will come from that in the form of an accident.
if it was a mere knowing sale, there would be no cause of action based on the express content of the statute. I want to go back from.
I'm sorry, what do you mean by that? You mean it
If
also
it
has
was
to be
merely,
unlawful?
if it was merely knowing, Chief Justice Muniz talked about a knowing sale to a minor. If it was a merely knowing sale, whatever that means, and I haven't taken on that burden for the moment, I think this court in Ellis says it means negligence. If it was a merely knowing sale, there would be no cause of action under 768.125. Nobody can argue with that. That's
Knowing
what
is
is required.
The unlawful doesn't require that it be knowing. So the word willful, so the sale is what makes it unlawful. The knowing is what makes it willful. That's the textual.
Well, in reading the statute that way, you have equated the terms willful and knowing, which the court in Ellis said were absolutely different and reflected an intent of the legislature to elevate, as we say, the burden of proof imposed.
You can have 1 minute to finish up.
All right, thank you. To respond to something that we were talking about previously, the action is not a negligence action unless it is based, I'm quoting from 768.811C, based upon a theory of negligence. As we've argued to the court, this cannot be a negligence claim because the legislature has prohibited bringing a negligence claim, and it cannot meet the definition of any of the other forms of action that are described. And it was the duty of the court, the trial court, and of this court to consider what it is that we are suing for and decide whether it fits one of those theories or is like one of those theories. I want to say one thing to sort of wrap up about my impression of the First District's decision in this case. I think that the court, as some of your honors have indicated, is struggling with the idea that joint and several liability remained as between the two bars in this case. And that is what informed the court's decision making, because we do have people who voluntarily, to some extent, participated in the consumption of alcohol. But as one of you all mentioned this morning, the statute exists for the purpose of their protection. And yes, it does impose liability under these circumstances. And then just finally, if I may, with respect to 768.36, and in response to your Honor's prior question about the application, I do want to make clear that the First District indicated that as between, certainly as between in a one-bar case, that the statute would not apply. And I believe that that's correct. It shouldn't apply because it would be irrational to apply the statute to a cause of action based on intoxication and then take away the cause of action because of the intoxication. So we don't think that the court should rule that 768.36 applies, even if the court disagrees that this case falls outside the comparative fault statute.
Okay, thank you very much.
Thank you, Your Honor.
Okay, we'll now take up number 220417, Dettel versus State of Florida.
Mr. Chief Justice, may it please the court. My name is Dimitri Pedoves, and I represent the petitioner, Matthew Dettel. This case is before this court on a certified question, which is whether this court's decision in Lee v. State applies retroactively to post-conviction proceedings. We're asking this court to answer the question in the affirmative and hold that Lee does apply retroactively. Before I get into the issue of retroactivity, first I'd like to briefly discuss this court's decision in Lee. Before Lee, this court held in Shelley v. State that convictions for solicitation and traveling violate double jeopardy if they're based on the same conduct. And in Lee, this court addressed how courts should determine whether convictions are based on the same conduct. And there was a conflict on that issue. The first district had said you can look at the entire record, look at the evidence, but the second and fifth district had held no, you look only at the charging document. And this court agreed with the second and fifth districts and held that you only look at the charging document.
Help me understand how that is a decision of fundamental significance. Analogize it to those that we have held are.
So the way you figure out if a case is of fundamental significance is you apply the three-factor WIT test. And those factors are the purpose to be served by the new rule.
You mean the link letter test?
Right, the link letter test that this court adopted in WIT.
Right, okay.
So the first one's the purpose to be served by the rule. And the way you look at that is you look at would retroactively applying the rule serve its purpose. For example, I cited in the reply brief a case from this court called Williams, which involved an exclusionary rule. And this court said, you know, it wouldn't serve the purpose of that to apply it retroactively, because the purpose of an exclusionary rule is to deter police action, and you can't deter past action. So retroactively applying it wouldn't serve its purpose. And the court did the same thing in link letter, that also, the Supreme Court. That also involved an exclusionary rule, and the court said we're not going to serve its purpose by applying it retroactively. But here, applying Lee retroactively would serve its purpose. By applying Lee to Mr. Dettel and others like him, you would vacate his lesser conviction and thereby not place him in double jeopardy. So that's the first factor, the purpose. The second factor is reliance. And here, in the first DCA, the state said there was little reliance on the old rule. And I agree with the state. There was little reliance. As I mentioned, the second and fifth districts were already holding that you look at the charging document. The first and third districts were taking kind of inconsistent approaches, and it seems only the fourth district was holding that you look at the evidence. And the only reliance interest the state has identified is that some prosecutor may have drafted a charging document thinking that the court or viewing court would look at all the evidence. But that hardly seems like a justified form of reliance, that a prosecutor would knowingly draft an ambiguous charging document because he expects that the evidence at trial will show distinct acts. So that's a very low reliance interest. And then the final factor, which I think is the most important here and which distinguishes this case from a lot of cases where this court has denied retroactivity, is the effect on the administration of justice. And the reason why that's important here is because retroactively applying Lee will not have a great effect on the administration of justice. This isn't a case where you're going to have retrials of stale cases where witnesses are going to have to come back, you're going to have to reopen evidence. All you have to do is look at the charging document. See if it clearly distinguishes based on distinct acts. If it does, that's the end of the analysis. If it doesn't, and there's the offenses are the same for purposes of Blockberger, like here, then you just vacate the lesser conviction.
Counsel, I understand what you're saying, but I'm having trouble seeing how we would look at this as a judicial upheaval, and we would look at it as anything other than an evolutionary refinement. And those are elements of the analysis that we use, correct?
I disagree, Your Honor. I don't think they're elements. I think they're labels, and I think that's
well, they've certainly been a part. If we put the word element aside, but they've certainly been a significant part of our analysis of underwhit. Isn't that correct?
That's right. I mean, that's how this court described the cases.
Well, so I go back to whatever we have, however you want to characterize those categories. How do you fit this within those categories?
Precisely by applying the factors I just discussed.
So basically what you're saying is that those categories don't mean anything.
They're just labels. It's not.
You're saying they're meaningless labels.
I'm saying that they're labels that you determine by applying the factors.
Well, but that's why I asked you to analogize this to the cases in which we have, in fact, given retroactive effect. Mm-hmm. You've done a very competent job of walking through the Linkletter test, whatever Witt's fate is. But I think what Justice Kennedy is asking is compare this to sometimes where we have, in fact, given retroactive application to a holding in the criminal context. Can you see how one of these things is not like the other? I mean, can you perform that analysis for us?
Yeah, I'll admit there's no case that is exactly like this, where this court has applied a case retroactively. But I think it's more helpful to compare this to cases where this court has denied retroactivity and see why this one is different. In most of the cases where this court has denied retroactivity, they're capital cases where you would have to reopen a penalty phase. They're cases where you have to have new trials, and you don't have anything like that here. So I don't have a case that's exactly the same.
It's hard to say that if you win, this won't result in new trials. I think that's a fairly tough road to hoe. Don't you agree?
No, Your Honor. The remedy of Lee is you just vacate the lesser conviction. So you don't hold a new trial. At most, you would have a resentencing. But all that vacating the lesser conviction would do is reduce the points on the score sheet. So hypothetically, the defendant could be resentenced to a lower sentence, but that's unlikely. Most defendants aren't sentenced to the minimum. And even here, in this particular case, you wouldn't even need to have a resentencing. Mr. Dettel has already served his sentence for the greater conviction, so vacating his lesser conviction would just end the matter, so there wouldn't need to be a resentencing.
So, counsel, you're saying on one hand that this is of such fundamental significance that we should apply it retroactively, but here you're saying it's really not going to make much of a difference in a majority of the cases. So why does that not work against your of fundamental significance argument?
I do want to be clear. It is going to make a difference to the defendants. This is really important to Mr. Dettel, and it's very significant.
It's important to most defendants, what's on their score sheets. That doesn't mean it's of such fundamental nature that we should change and make this retroactive.
And that's why I think it's important to focus on the factors, because this isn't a I know it when I see it kind of test.
That's debatable. I mean, I think the best argument against that is hearing an articulate, smart person go through the factors is probably the best argument in favor of getting rid of that test. But go ahead.
Well, Your Honor, I mean, my point is simply that this court, the way this court's explained it in Witt is you apply the factors. You don't just look at a case and say, oh, is it fundamental, because I think it is. I mean, Witt says you apply a case-by-case analysis and you look at the factors.
Well, do you want to address why Teague wouldn't be a better standard to apply?
I think Teague is unduly harsh. I think it gives this court less flexibility. And I think that's why some other courts have chosen not to adopt Teague.
What is our framework? Are we kind of roving federal standards to decide which one we like the best? Or is there some rooting principle that we should look at for how we evaluate in post-conviction matters whether a case is retroactively applied?
The two factors that this court identified in Witt are fairness and finality. So those they're kind of like policy principles that are guiding this court in what tests to apply. And Witt already took account of finality. Nothing about the concept of finality has changed since this court decided Witt. But what Teague does is it leans too much towards finality and goes away from fairness. And I think that's what some other courts have recognized, that Witt does allow this court to consider the particular case, the effects on the administration of justice, which really is what finality is. One of the things that finality tries to take account of is.
I think. All right. So both Witt and Teague are, balancing the finality interest. In Witt, we said that in order for a rule to demand retroactive application, here we were talking about the purpose to be served by the new rule. The rule must, quote, cast serious doubt on the veracity or integrity of the original trial proceeding. I'm wondering how, in this case, that standard is met. Do you believe that the underlying proceeding is in serious doubt in terms of its veracity or integrity?
I think the Lee rule protects that interest by making sure that reviewing courts.
That's like a 18-word no, I'm getting. Can you give me it in fewer words?
I mean, if you're asking me was there evidence of multiple solicitations here, I think there was. But the point is, reviewing courts shouldn't be making that determination. Maybe it was clear here. What about in a case where there's two witnesses who said the opposite thing? Is the reviewing court going to look at the evidence and make a credibility determination to see whether there were distinct acts? I think it's a much clearer, bright line rule. And the state, one of the reasons it wants to adopt Teague is because it's this bright line rule. Well, that's what Lee is too. It just says look at the charging document. Don't look at the evidence and try and second guess what the jury might have done based on a stale record.
Counsel, is there anything in Florida law, the statutes or the Constitution, that constrains how we deal with this? I'm talking about whether we have a standard like Witt or we have a Teague-like standard or some other standard. Are we constrained by any authority? I'm not talking about our prior precedents. I'm talking about something in statute or the Constitution.
Not that I'm aware of in Florida law. The only thing I'm aware of is Montgomery, the U.S. Supreme Court decision.
Well, obviously we're constrained by them.
Right. But no, this court didn't identify anything like that in Witt. It just sort of decided this is what we're going to do as a matter of fairness and finality. This is how
So what's the authority for us to do it?
The judicial power. There's no separate.
Inherent judicial power.
Right.
So when we're talking about judicial power, why would we not? Why is it not more consistent with the judicial role to look towards 924-066 as our post-conviction statute? It allows, subject to the terms and the conditions, to seek relief based on judgments of convictions or sentence that were imposed in violation of the Constitution or the law of the United States. That's starting to sound a lot like Teague minus watershed, right? I mean, if it's in violation of the statute or of the Constitution, that sounds like a substantive test gives effect to our post-conviction framework in Florida.
Well, the Constitution was violated here too. This is a double jeopardy case, so there's a constitutional claim here. Mr. Dettel is claiming that his constitutional right not to be placed in double jeopardy was violated.
Can you fit that into the substantive framework that Teague provides?
Yes, in my reply brief, I cited 3 cases from the 11th Circuit, the 8th Circuit, and the District Court of Puerto Rico.
How would you square it with Welch versus United States? Are you familiar with that case?
No, I'm sorry, Your Honor.
That's fine. I'll look at those in the reply brief.
Okay. And what those courts held is that a double jeopardy rule does fall under the substantive Teague element. And the state hasn't really identified any cases that hold otherwise. They cited 2 cases with a CF site, so I don't think they're very confident about them. But neither of those really dealt with the issue. The first was Kaspari, and that was whether a state has to do another sentencing proceeding after someone's retried. And the court said that's not a substantive rule because it doesn't place conduct beyond the state's power to punish. But the double jeopardy clause does do that. It says you can't be punished twice for the same conduct. So the Kaspari case is distinguishable. And the other case the state cited, Dawson, that defendant didn't even raise the substantive exception. So that wasn't addressed there. So I've identified 3 cases for this court where courts have held that a double jeopardy rule does fall under the substantive exception, and the state hasn't identified any holding otherwise.
This is really about a procedure for determining whether such a violation occurred. It's not like that we're saying that double jeopardy violations are okay. It's a procedural matter about how a determination is made. Doesn't that make a difference?
I think you can often recast things as a procedural thing instead of a substantive issue.
And you can sometimes recast procedural things as a substantive matter.
So I obviously this, Lee is what it is. It tells you how to determine whether distinct acts were committed. But I think it so supports the double jeopardy right, the right not to be placed in double jeopardy, and it protects it in such a significant way that it is really more of a substantive rule. It's effectuating the double jeopardy clause. Without Lee, the double jeopardy clause becomes almost meaningless in this context. So that's why I think it should be considered a substantive rule. Unless this court has any other questions, I'd like to reserve the remainder of my time for rebuttal.
Thanks.
Mr. Chief Justice, and may it please the court. Justice Lewis, who himself was no fan of more restrictive retroactivity rules, in his separate opinion in a say, called wit a dizzying rabbit hole of untenable line drawing. And we think that's exactly the kind of thinking that has led 5 justices since 2004 to recommend that this court recede from wit and adopt the federal standards laid out in Teague, now as modified by Edwards versus Van Noy.
Well, yeah, but isn't it the state's position that under wit, under Teague, we reach the same result, that Lee doesn't get retroactive effect?
We think if you are simply applying precedent, then this is a remarkably easy case because you apply Glenn and it's game over.
I'm having trouble hearing you. I'm sorry. Could you speak up?
Sure. So we think that if you're just applying precedent, then the applicable precedent would be Glenn.
About Carawan, right?
Exactly, which was a rule that I think looked far more substantive than the rule at issue here, but all of the same reasoning from Glenn would apply here. And I think it's tough for them to get around that. The reason that we think you shouldn't just apply principles of judicial restraint and resolve the case just by applying Glenn is because of the harm that the wit rule has caused to the state and the public's significant interest and finality over the years. So as I mentioned, in 2004, there were 3 justices in a case called Wyndham who argued that we should get rid of wit and adopt Teague. They argued effectively all the same points that we've argued in this case, but they didn't have a 4th vote to get rid of wit at that point. And as a result, wit stuck around until 2016, when this court had to decide the retroactivity of Hurst versus Florida. And the result, I think, was deeply incongruous, because you said in a say that that Hurst didn't apply retroactively to any capital inmate whose conviction was final before 2002. But in Mosley, released on the same day, the court, applying that malleable and vague three-factor balancing test from Linkletter, held that Hurst was retroactive to those whose convictions were final after 2002. It's hard to imagine a greater injury to the state's interest in finality than the Mosley opinion. Not just because of the vast financial cost to the state of retrying some 150 capital inmates at the penalty phase, but also the incalculable harm to the victims and to the public of having those cases reopened. So that's the harm of the rule.
Let's say that we agree that from a consequential perspective, the rule has harm. Isn't the right analysis, though, whether it's clearly erroneous? Whether wit is clearly erroneous? I mean, the test is something we've decided a hopeless rabbit hole, or whatever it was Justice Lewis said, because God help us, there'd be a lot of those. Isn't the right inquiry whether or not wit is clearly erroneous? And if so, can you tell me what the clear error of wit is? It's ungainly, perhaps, but where's the clear error?
So in Poole, what the court said of clearly erroneous precedents was that when you determine that a precedent is clearly erroneous, there's a presumption that you will overrule it. And then you look to reliance interests first and foremost. I'm not familiar with a case where the court has said that it will only recede from clearly erroneous precedents. That's just a threshold matter. I'd push back on that premise. But in any event, we do think that wit is clearly erroneous because of the way that it balanced the defendant's interest in fairness.
How would we, when we're making a determination about clearly erroneous, whether something is clearly erroneous, but say in the interpretation of the statute particularly,
right?
We look at the statute and we judge what we've said against that authority. What's the authority here that determines that we would look to determine whether it's clearly erroneous? What we've said and whether it's clearly erroneous.
Well, the way that retroactivity jurisprudence has typically proceeded is by balancing practical considerations. Saying on the one hand, I agree with my friend, saying on the one hand, we have an interest in fairness to criminal defendants. We also have the state and the public's interest in finality. And so courts have struggled to draw that balance, and we think the U.S. Supreme Court eventually got to the right place. I'm not sure that there, Justice Sasso, is any clear textual source of decision-making on this point. I think the statute that you discussed does, perhaps point in the direction of adopting Teague, but I'm not sure that anything is quite clear. And at the end of the day, this is probably a question of court procedure for this court.
If there's a statute, why wouldn't we look to that to determine whether we are acting within our authority? Because ultimately, our what we've said about receding is we don't want to act outside our authority. We don't want to adhere to a precedent that is an abuse of our authority.
I understand. I think that, well, in the wake of Gideon versus Wainwright, the court adopted Rule 3850. It's a procedural rule. I think it's largely a question of court procedure, and I think the question of when do you retroactively provide relief, the legislature may be able to say something about that, but I think at the moment, if it hasn't spoken clearly to that, then it's a question of procedure for the court to decide. You could, I think, if you wanted to, tomorrow amend Rule 3850 to adopt a specific provision dealing with this issue. And I think if you were to go the rulemaking route, which we think you could just do in this case as a matter of interpretation, but if you wanted to go the rulemaking route, you could do that and you could enshrine Teague in the rule.
Well, when you look at like Edwards versus Vinoy and the methodology that they're applying, I mean, looking at concerns of federalism, the federal post-conviction statute, these are kind of, the point of the retroactivity test is to give effect to the post-conviction framework, right? I mean, that's what we're trying to accomplish. We're trying to determine what test best suits this post-conviction framework, or is there some other consideration?
I think that's right, although that doesn't necessarily mean that the text speaks directly to the question.
Correct. Yes.
So, if you look at the dissent in Montgomery versus Louisiana, the way that the dissenting justices characterized what Teague was doing was grappling with the federal habeas statutes. Now, Teague itself doesn't point to any particular piece of text that says our rule is dictated by that text. It did resort to balancing. But we think even if you were just to do the same sort of thing that you did in Witt and that the Supreme Court did in Teague and just balance, we still think that Witt is clearly erroneous because of the way that it's drawn the balance. This court in Poole, in a paragraph, actually, I think, receded from cases on stare decisis. Instead, there is this 4-factor balancing test out there for deciding when you stand by a precedent or you don't. And that kind of balancing is so malleable and so in the eye of the beholder that it is not principled. And too often is simply, I think the phrase that the court used in that case was that those kinds of balancing tests too often simply provide a toolbox of excuses for reaching a result preferred by a majority of the court. Witt creates that problem, and Teague does not. Teague gives you something objective to look to.
And can you talk about what Teague really is? I mean, we talk about a lot substantive versus procedural, but it's not really a binary, right? It's a general rule against retroactivity, except for in the case where it's a substantive issue, substance being defined as the conduct that led to the criminal conviction, right?
Correct.
Okay.
Correct. And if you look back to the middle of the 20th century, the way that habeas was being used, particularly in the federal courts, it was not being used to litigate rules of procedure at all. The rule in federal habeas in the 1950s up until the 1960s, and this is explained in Montgomery, was actually that the only way that a habeas petitioner could get relief was if they could show that they did not get a fair shake in state court. In other words, that the state courts just wouldn't hear the claim, or if they brought a substantive challenge to the constitutionality of the statute under which they were convicted. And I think that's perhaps part of what's animating what's going on in Teague, where Teague draws this line that says, if substantive, then we will consider it retroactively in post-conviction, but if procedural, then we won't. One other consideration, I think, in defense of that dichotomy, substance versus procedure, is the different nature of how those types of rules typically operate. When a court retroactively applies a substantive rule, generally you do not generate more judicial proceedings, or if there are more, they're quite limited. Because a substantive rule would say something like, the state simply cannot convict you for this offense. It would be a violation of the First Amendment or the vagueness doctrine. In that instance, typically all you do is vacate the conviction. You don't need to do much more than that. It's a very different story when you're talking about rules of procedure, and Edwards versus Van Noy does a nice job of laying this out. When you're talking about rules of procedure, ordinarily the remedy will be more proceedings at which the correct procedure is applied. Are there any questions about whether or not this is a substantive rule, or that Lee is a substantive rule or a procedural rule? That's certainly an argument that has been made in the reply brief. I think Glenn in and of itself is probably inconsistent with that. But if you look at the way that Lee described what it was doing, it said it was dealing with the how of figuring out whether there had been a double jeopardy violation.
Is the state's position that in order for it to be a substantive rule, to give sort of meat to that skeleton, we're really talking about whether or not the rule puts a class of conduct inside or outside the scope of prosecution?
Correct.
So that's what we mean, or that's what the state means when it uses the word substantive rather
Correct.
than procedural. I mean, if that's true, then essentially what the state's position is because Teague takes out the link letter factors, then the only question this court should have, and this is sort of contra Justice Contero's concurring opinion, and now I can't remember what case it was, is that concern. Like if the rule has no effect other than to alter anything that other than the behavior and whether or not the behavior gets prosecuted, it is a procedural rule.
Well, I think that's right, Justice Carroll, with the caveat that there are sentencing substantive rules as well.
Okay.
Roper versus Simmons, right? A rule that says you cannot impose this punishment for this category of offender. You can't execute juveniles.
Right.
So both of those things, I think, so that's an easy way to do it, really. You just ask, okay, is it substantive in that sense? And if the answer is no, then by definition, it must be procedural. Are there any further questions I can address? Thank you.
So first I'd like to start with WIT. The state made it seem like WIT has caused all these problems and been such a disaster for the state, but where's the evidence of that? How many times has this court retroactively applied a decision under WIT? Very, very infrequently. And it's repeatedly said that it should be rare. So I haven't seen any negative consequences from WIT. Second, the state mentioned the Glenn decision. I distinguished that case in the initial brief. I gave 4 reasons why it's distinguishable. I think the most important one is that the issue in Glenn was whether this court was going to retroactively apply a decision about statutory intent. And the legislature had already come out and said, no, you got statutory intent wrong. So why would you apply a case retroactively when the legislature has told you the analysis of intent was wrong? So that's a big distinction with Glenn. Third, the clearly erroneous issue. I think under Poole, the state does have to show that WIT is clearly erroneous for this court to recede from it. There's certainly no case law that I'm aware of that says you don't have to show that.
Well, what standard would that be judged by? I mean, what do we look to determine whether it's clearly erroneous?
I agree it's more difficult in a case like this.
Well, it may be impossible because
I think what you can do is you can.
I'm going to conclude. I may conclude it's impossible unless you can identify what it would be.
So you would look at the WIT decision and see, is it internally inconsistent? Is there some logical inconsistency in that decision? Does it make sense? Has it applied the precedent that it applied correctly? So there's ways you can still do that.
Does it make sense? And if it doesn't make sense, it's clearly erroneous. Is that essentially the test?
In this kind of context where you don't have some other thing you can look at, for example, when statutory analysis, you would just look at, did it interpret the statute correctly?
I think maybe the better argument, both for you and for the state, because I think you just take different positions, is to go back to what Justice Sasso was saying and look at the constitutional interests to which the statutes point. You could, for example, say, WIT promotes finality because it is more capacious in how it allows you to judge the effect on the administration of justice, whereas Teague v. Lane doesn't give you that. I mean, why isn't that your position?
I mean, that works too, so. I did want to point out, if this court isn't going to hold that Lee is retroactive, this court recently said in Youngkin v. Blackwelder in 2021, certified question jurisdiction should not be used to recede from case law. When doing so would have no impact on the issue properly before the court. So if this court isn't going to apply Lee retroactively, it has no reason to recede from Lee or WIT. And then finally, the state said Teague is great because under the substantive exception, all you do is vacate the conviction. That's exactly what we have here. Under Lee, all you do is vacate the lesser conviction. There isn't going to be any retrial. There aren't witnesses and victims aren't going to be dragged back into court. It's really just as simple as looking at a one-page information. And for all those reasons, I'd ask this court to answer the certified question in the affirmative and hold that Lee does apply retroactively, and therefore Mr. Dettle's conviction for solicitation and his sentence should be vacated. Thank you.
Thank you very much. We'll be in recess for 10 minutes.
All right.
So you're supposed to because I was like already standing up. I think he was like, sit down.
Just very smart. You sensed a problem immediately.
It's almost maxed out.
Yeah. Gotta work. The federal court in Jacksonville, I don't used to have a podium this long, didn't lower. And I want that margin, she had to stand like 4 feet from the podium just to have, it was so, it was over her head.
All rise. Supreme Court of Florida is now in session. Please be seated.
Hi, we'll now take up case number 220984, Marina Bay Resort. I'm sorry, Seidler versus Marina Bay Resort. Thanks.
May it please the court, Charles Bell on behalf of the petitioner, James Seidler. My colleague, Mr. Mills, will be focusing on some of the issues from the amicus briefs, but I'm going to focus on the fact that the First District's decision below was contrary to two different lines of precedent from this court. First, the First District's decision is directly contrary to the line of cases beginning in Hill, continuing through Trotter and Busby and Matarans, holding that an error in a jury selection with a cause challenge, if it is fully preserved, cannot be harmless. And second, even if the First District was correct in applying the harmless error analysis that it did, the district's analysis cannot be reconciled with this court's opinion in special because the court flipped the burden of proof in its analysis. Either holding by itself requires the decision to be quashed, and Mr. Seidler should be entitled to a new trial.
So I know that the court sort of came up with this harmless error thing on its own initially, but then when there was the rehearing, I mean, was the special thing, was that argued? I mean, it just seems odd that it was never, that the court just completely didn't address that.
It does seem odd, the whole thing, and in fact, Marina Bay below never argued for harmless error at all. That's the odd thing about the whole proceeding, quite frankly, is that everything sort of came out of thin air to everybody, and that's why I think this court, frankly, needs to address it, because the court below did not offer any justification for being the first court in over 38 years to essentially not apply 9 different precedents from this court on that analysis. The only justification was offered is in Judge Tannenbaum's concurring opinion, which of course the other 2 judges did not adopt, but even if they did, that civil cases are different from criminal cases. That's really the only basis.
That's only potentially relevant to the per se thing. That doesn't affect whether you do harmless error. It doesn't affect what harmless error analysis would require and all that.
Exactly. In fact, I would simply defer to the state's brief on that point, which I think hit the nail on the head. That Judge Tannenbaum's analysis simply doesn't have any basis in Florida law on that particular point. This court has never viewed, as I think you were getting at, Justice, it's never viewed the type of error, the type of case as affecting the type of procedure. That's why special and DiGilio are basically the same standard, just one for criminal, one for civil. So this court has always applied those things together. And for that reason, the entire justification offered by Marina Bay just falls by the wayside. There is simply no way you can reconcile what the First District did, either in original opinion or in rehearing, with this court's 38 years of cases, and that's as simple as it is. Now, we understand, but I guess the elephant in the room we need to address is that even on our side of the aisle, we can't necessarily agree on what this court means in those other 10 cases, and I suspect there may be some disagreement amongst yourselves, because the court, candidly, never uses the words per se reversible in any of those opinions from Hill all the way up to Matarans. That's not the way the court did. In fact, the only time that comes up is in the concurring or dissenting opinions explaining the court's rule. But again, I don't know that it matters for purposes of this, but for jurisprudential purposes it does. And I think at this particular point, the important thing is that this court has held that per se reversible error is rare, but there are times when it is required. And among those times are when you have to engage in pure speculation. That's what the court said in Davis just 1 year ago tomorrow. Pure speculation is one time when you do this. Is it going to be pure speculation in this particular situation? And again,
doesn't
I
that
think
require us though to kind of like factually remove ourselves from what the error is? Because the error that's being appealed is the denial of the for-cause challenge.
Yes.
Correct?
Yes.
And that error was indisputably cured. By use of the peremptory,
Exactly.
the error that occurred, that is a reversible error, was cured. And so if we then start focusing on the effect of the peremptories, aren't we moving away from what reversible error is into some other area where now we're creating some right to a preferred jury that doesn't necessarily exist?
Your Honor, I guess I would disagree with that perception, because again, I think that the cure, in a sense, causes the error here.
Well, explain to me why that is reversible error.
Sure.
Why is not having, one preferred for a non-articulated reason a reversible error when there's no bias, there's no evidence that there was not a fair trial, there's no legal error? Can you explain that?
Sure. I would say I'll give you two answers, but they're related. One is that by rule, this court has allowed civil defendants and plaintiffs a choice in their jury. Now, the court may not need to do that constitutionally, but the court has done that. So each side gets 3 peremptory challenges, and we're entitled to use those. Because Marina Bay had to use one of its challenges to correct the trial court's own error, we only had 2. That took away one of our choices. The other side of this coin, and I think it's very important, is that by doing that, it made an unequal playing field, because Marina Bay got the full choice of its peremptory challenges, and we did not. And if I have an analogy, I think it may give you all flashbacks. I apologize for this, but go back to your law school bar exams. If you had essays, you had to do 3 essays, and Judge Sasso, they said, okay, here, professor gives you, he said, answer 3 essays in your torts class. That's all well and good. But if Justice Kennedy is said, okay, here's 5 essays, choose the 3 you want to answer. You're both going to answer 3 essays. They may be fair essays. They may be graded by the same professor, but nobody in this courtroom thinks that's fair.
But doesn't that take us into the consideration of whether or not a trial court abused its discretion in denying an additional request for a peremptory, rather than framing the issue of whether the denial of the for-cause challenge was harmful error?
Perhaps, but I also think that whenever a cause challenge should have been granted, as in this particular case, the trial court necessarily abuses its discretion by not allowing that to be cured. I mean, the trial court basically—
But that's a different appeal, isn't it? I mean, that would be an appeal of, did the trial court abuse its discretion, yes or no? And that's not how this issue has been presented to us. It's been presented on, was the denial of the for-cause challenge harmful error that constitutes a basis for reversal?
I think that's correct, but that is not that's not what this court's decisions over the years have held. Basically.
Well, and you're asking us to clarify. So when
Yeah.
we talk about clarifying, I mean, what are we doing here? Are we trying to make sure everybody gets 3 peremptories in every case, or are we trying to prevent the error of a for-cause challenge, which goes to juror bias and the right to a fair trial?
I think they're tied together. I think they're tied together because, again, had the cause challenge been granted as it should have been, we wouldn't be here. But because the cause challenge was not, then you compound the error by essentially giving Marina Bay 3 peremptories and giving Mr. Seidler 2 peremptories that he had to use on a juror that should have been stricken for cause. And I understand that is maybe an abuse of discretion standard, but that's not what this court has held over the years. The court's basically said if the trial court makes an error, if you ask for a peremptory, the trial extra peremptory, you identify the juror, it's denied, you get a new trial. And that's been the rule for years, and respectfully, we see no reason to deviate from that rule. I'd like to reserve the rest of my time for rebuttal, if that's okay, and let my colleague answer additional questions.
Thank you. Good morning, and may it please the court. I'm John Mills on behalf of the amicus, the Florida Justice Association, whose brief I authored, but also with special permission from the Florida chapters of the American Board of Trial Advocates, which is a neutral organization equally composed of defense and plaintiffs' civil lawyers. I want to address 3 points today very quickly. The first that I'll focus on is there's no argument here that existing precedent was clearly erroneous. We just heard about that before. There's supposed to be an argument about that before we retreat from existing precedent.
But isn't existing precedent really, the initial precedent that this is arising out of was a preservation rule, and then we go to a harmless error standard, and then in the application of the harmless error standard, the court identifies a subcategory of cases where the error can't be harmless, but it's not really a per se rule. There's been several situations identified where this error would not lead to a harmful result, even considering the facts of this case.
Absolutely, and I agree. Whatever difficulty there is in the case law is in nomenclature and semantics. It's conflating preservation with harmless error. I teach CLE on this. I've been to CLE. This is just how we're taught. It's preservation. But I think if you look at it, it really is a harmless error issue. And the case law that's been applied has applied harmless error. And the decision this court issued just last year in Davis is a great example, and I think it provides a good framework, that if you apply the same framework, you find out that maybe there's some semantic errors, but the actual test applied is the exact harmless error test that's applied in every case. And to your point that you just made, I think it's another semantic point. Using a peremptory on the biased juror, that does cure the harm of the erroneous denial of the cause challenge. It does. But it just creates a second harm. The harm is the denial of the equal number of peremptory challenges. This court has said that's important.
It's important, but you'd agree it's not of constitutional dimension.
It's not, but neither. So if a juror conceals information that doesn't show actual bias but would lead to a peremptory challenge, we have years of case law that says that leads to a new trial because a peremptory would have been used there. It affects the composition of the jury. And where Justice Lawson went wrong, and Justice Bell before him, in their dissenting opinions, asking this court to change the law on this, is they said they're applying de Julio, special for civil cases, and they correctly articulated that standard, but then they immediately proceeded to apply a different standard. And this court in Davis first said...
Well, why wouldn't they have correctly applied de Julio in the context of the for-cause challenge? I mean, the harm is cured. We can say very clearly on the record that any harm that occurred from the for-cause challenge did not contribute to the verdict in the sense that there is no bias juror.
Well, it contributed to the verdict because it resulted in the erroneous denial of a peremptory challenge, which, if it's harmful, and we say it is here, affected the result because it affected who was on the jury that rendered the verdict. And if it impacted the composition of the jury that rendered the verdict, it's going to be harmful unless the jury rendered a verdict that's as favorable to the party who lost the cause challenge as they could have expected. No reasonable jury would have given you any more damages, Mr. Seidler, so it's harmless. That was the kind of harmless error argument that the defendant could have made here, and they didn't, presumably because the record doesn't support that. But look at Davis. In Davis, the second DCA said exactly what Justice Lawson said we should do. Look at the kind of error. If the error affects a fair decision maker, let's look at harm on did you get a fair decision maker. And this court unanimously said that's wrong. You do not do that. You do not apply a different standard depending on the error. This is because there's a statute right on point. And the statute says it applies to civil and criminal cases. This is
but that standard is a little inconsistent with the statute. I mean, I know that de Julio is, and special, is interpreting that manifest injustice language, but when the statute says you don't reverse unless there's a manifest injustice,
right,
that suggests that there needs to be some sort of demonstrated manifest injustice, which would put the burden on the proponent of the reversible error, but our test has kind of flipped that.
This court unanimously rejected exactly that point in Davis. That's what the second DCA said, and this court said no. The standard, the fundamental, the miscarriage of justice, what that means, we're interpreting it, we're going to interpret it the same way we have always, for a long time. In de Julio, we extended it to civil and special, and even the dissenters in there agreed the approach is still to put the burden on the appellee. The only question was whether the standard changes because of reasonable doubt versus more likely than not.
But you agree, I mean, so if there's a failure to prove a manifest injustice, that breaks in favor of the appellant, right? Because if you can't demonstrate either way,
the appellant,
and the burden is on the beneficiary of the error, it breaks in favor of the appellant.
It does break in favor of the appellant.
Because that's kind of inconsistent with the statute, though, because if the statute's requiring a manifest injustice and we're saying we can't demonstrate on this record, we be speculating either way, then there in fact could not be a manifest injustice. We don't know, but it's the burden is on the beneficiary of that error.
This court in de Julio interpreted the phrase miscarriage of justice to mean that if there is an error, that's going to be a miscarriage of justice unless It's shown that it didn't impact the result. And we have to say, how do we determine that? And precedent, which nobody said or explained why it's clearly erroneous, interpreting that statute, the legislature hasn't had a chance to say, no, they've left it in place, that the burden, we're going to place the burden on the beneficiary of the error to show no reasonable chance of a different verdict. And that can't be done. It can be done in lots of ways with a juror issue. But one way it can't be done is if the jury that rendered the verdict had somebody that would not have been on there but for the error. Civil or criminal, it's a unanimous requirement. And this court said in Turkutsk, the change of a single juror and the composition of the jury could change the result.
So does that mean, though, that, because it sounded like earlier you had said that the harmless error test could be met depending on what the outcome was. It seems like if you're focusing on jury composition, then once the person actually is part of the deliberations and whatever, then...
No, it would still be harmless, even if it affected the composition of the jury, if the verdict that was rendered was as favorable as the person who suffered the error could expect. So if this jury had awarded, they found for the plaintiff on liability. Had they awarded every dollar that was sought by the plaintiff, there'd be nothing to appeal. I mean, if they wouldn't appeal.
Sorry, go ahead.
I mean, how would there ever even be an appeal? I mean, how would the question...
I think it probably takes care of itself, but that could be the argument. There was an argument there that they got all that they deserve. And if
I don't necessarily think that you're wrong in big picture, but I think one of the things that probably everybody who thinks about this struggles with is the idea that, it's one thing to say, the per se reversible thing, that doesn't seem right, we should go through the harmless error thing, but it does seem like if you look at what the court has said about the issue is the effect on the trier of fact, and if the trier of fact is sort of defined by what the error is, it just seems like whatever we call it, you're always going to end up in the same place of having to...
I think you do. We've created these preservation rules that take care of almost every harmless error. So I think it's probably more properly viewed as harmless error than preservation, but either way, it gets our tipsy coachman makes it into the house. And another crucially important, and this is on behalf of not just the FJA, but Floboda. This is a neutral issue. This is about whether peremptory challenges. This isn't about cause challenges. This is about peremptory challenges and whether they're worth anything. And courts sometimes denigrate peremptory challenges by saying they can be used for any reason, they can be used arbitrarily unless they're discriminatory. And yes, people say that because we don't review it. That's not the purpose of a peremptory. The purpose of a peremptory is the same as a cause. It's so we have an unbiased jury. But it recognizes for 700 years, the King's Bench, we've had it all this time, it recognizes that the standard for proving actual bias is difficult. You have to do it on the record. You have to get somebody to admit they can't be fair. Folks don't like to say they can't be fair. Worse, you have concealed bias. You have the runaway juror. Maybe it's a tobacco case. This is where I do a lot of tobacco cases. And plaintiffs and defense, we are aligned. We're on the same page here. We got to have our peremptories. On the plaintiff side, we know that lots of jurors think smokers bring it on themselves. It's an intentional decision. And so you watch for that. And you may get somebody who says they can be fair, but you as a lawyer who's tried 50 cases can see that's not somebody who's going to be fair to my client. The other way, the defense, I've got a runaway juror here who's saying all the right things. This looks like somebody John Grisham's written about. They want this, he wants to be on this jury to send a message, they're going to get us. All kinds of different cases, all kinds of different cases. Either side can have legitimate reasons to worry, but can't prove the bias. That's why we have peremptories. It provides the cushion. And if you deprive one side of the same cushion you give the other side, that is a miscarriage of justice by any definition, and that is harmful error. Thank you.
May it please the court. Good morning. Mark Tinker on behalf of Marina Bay Resort, and at council table we've met already this morning. Mr. D'Souza is here on behalf of the state. I think, Justice Sasso, you kind of hit on a few of the main issues here. This isn't something, this is, get a few things out of the way. This is not an issue where there was a biased juror who sat on the jury. Nobody even challenged any of these people for cause. There's been no indication of that. What it is saying that they didn't receive the amount of peremptories that they think they should have received because they were forced to use one on this
Well, how do you
particular
square
juror.
that with the harmless error test and special?
The harmless error test, because I think that's exactly where this goes, is we know that the denial of a peremptory or the lack of peremptories, we know for a fact that in theory, I suppose we could say that can be harmless, because if they were to walk into court one morning and the judge says, okay, defense, you get 3 peremptory challenges, plaintiff, you get 2. And we know that's an error. That's an absolute error. They're denying them one of the peremptories that the rule says they get, but they only end up using one of them. They never even get there. We know it was harmless. So it can be harmless. What it gets to is if they were compelled to use this third challenge to strike someone, and then they identify another juror, what this court...
Here, right?
Correct.
So can you apply the harmless error standard and special to the facts of this case?
Okay, and that's where this case, I think, is unique, because what the First District did is said on the particular facts of this case, the harm in that having to use that third peremptory is that you end up with somebody who you believe was objectionable on your jury.
But that's not applying the test. So the test is, did the error, is it reasonably probable that it contributed to the verdict? So how can we say on contributing to the verdict that the unique nature of this one individual did not contribute to the verdict?
Well, if that is the way that the test is going to be applied, then I think you've just eviscerated harmless error in general.
Well, why should we not apply the test that way? I mean, that's what the words say of the test. And so if we apply the words of the test to this factual scenario, how do we not inescapably reach the conclusion that the identity of the juror matters?
Because you end up with here in this particular case is they were going to have an objectionable juror regardless. So under these circumstances, the First District said that looking at the fact that they're going to have an objectionable juror, that did not contribute to the verdict. Why I'm saying it would eviscerate the test is you can say that about anything that if there's a ruling on a piece of evidence, if witness A comes in and is going to testify to a fact and the judge excludes witness A, but witness B testifies to the same thing, and then a piece of hard evidence goes in, we sit there all day long and say that was harmless because the jury heard the same information. The striking of witness A was harmless because the jury heard the same information from witness B, received it in physical evidence, they got the same information just in a different format, therefore it's harmless. We don't know if the jury would have believed witness A. Maybe they didn't like witness B. Maybe they don't like to look at the physical documents. They really wanted to hear from A. We can't ever say that exclusion was harmless, but we do it all the time. The district court judges can look at it and say, because it's always a judgment call to say the jury heard the same information, therefore it was harmless. This is the same situation where there was going to be an objectionable juror no matter what they did. If they were given a fourth challenge, they would have used it the way that they wanted to. The next objectionable juror, who we already know that they objected to, would have just moved on to the jury, and there wouldn't have been anything they could have done about it because they would have been out of challenges and would have had no legitimate basis to ask for another one. So it's the same thing where the district court, the First District here, looked at it, and Judge Tannenbaum in his concurrence...
So if that's such a good argument, why did you guys never make it? I mean, you barely, even when the briefing happened, the supplemental briefing happened, you barely even adopted the argument.
Well, the focus originally in the appeal was whether this cause challenge, whether it was an abuse of discretion to even deny it.
Right. And it seemed like both sides were kind of operating under the established framework, for better or worse, that really the issue was just going to be, was there error in the denial? And if so, then we know that the person sat on the jury, that, that all the preservation steps happened. And so it just, the whole progress of this case seems strange. I mean, is it also true that you guys have not argued anything about our court's past interpretation of the manifest injustice term being clearly erroneous or anything like that, regardless of on the merits, if we were looking at it, what we would say? I mean, you kind of followed the first DCA's approach to just pretend that this special case doesn't even exist.
Well,
is that right?
No, I don't believe so, Your Honor. And I think I don't read the First District's opinion the way that counsel does. I know they cite the manifest injustice, they quote the statute, they don't refer to special, but that is what they're doing. They're saying, here's the statute for harmless error, this is not a manifest injustice because the same issue would have happened anyway, because an objectionable juror would have gone on the jury. So they're saying it didn't contribute to the verdict without using those words. They're just quoting the statute instead of quoting special, but it reaches the same result. So we're not saying that special doesn't apply or that the first district didn't apply it. They just quoted the statute instead of quoting the opinion, the special opinion. But as I was saying to Justice Sasso, I think that's exactly what happens here is this court has said the harm in that forcing someone to use the extra peremptory is that an objectionable juror ended up on your jury. And that was going to happen here anyway. And Judge Tannenbaum in his concurrence twice, both at the beginning of it and at the end of it, went to great lengths to say we are looking at this on the very specific facts of this case, that this is a unique situation. He said it again at the end. He said we didn't just reflexively decide this case based on whether this
have we ever said, though, I mean, it seems like the harm, I think it's been characterized as the particular objectionable juror serving on the jury. Has there ever been another case where a court said, well, objectionable jurors are basically fungible, and if you, for the same reasons that you wouldn't have wanted the one who sat, you also wouldn't have wanted the other one, therefore it doesn't make a difference? I mean, you know what I'm saying? It seems like it's sort of taking the past decisions out of context where it wasn't a matter of comparing a bunch of objectionable jurors. It's just, is this person an objectionable juror, and did they sit on the jury?
To answer your question directly, no, I don't think any case has ever said that, but I do think that our system of jurisprudence has to assume that unbiased jurors are essentially fungible. That if you have a panel of 6 people, and we have gone through the analysis to make sure that nobody biased is on your jury, that is a jury of your peers. Yeah. Of course, everyone is going to be different.
I guess the problem, though, is, if you just focus on bias, then the whole peremptory thing just doesn't even really make sense in terms of worrying about. As long as there's never really going to be a harm in that sense. I mean,
and that's why I think what Justice Sasso was saying is what it gets down to is the harm doesn't have to do with bias. Like I said at the beginning, we know that there was no biased juror here. What we're talking about is the lack of a peremptory. And is that a fundamental right where it's a per se reversible error? I agree with counsel. I think Davis just last year went through and described what per se reversible errors are. This certainly doesn't qualify. What the court looked at as far as speculation is if there's no record of what happened. For example, a bailiff has ex parte communications with the jury. We never know what was said there because there's no record of it. So the court has to consider it per se reversible. But the court in Davis said even the trial judge refusing to disqualify himself is not per se reversible because we can look at the record and we can see what that trial judge did.
Looking at the record here, it seems to me that to say the quiet part out loud, we are dealing with 2 different issues. One is making sure there are no biased jurors, and frankly, another is making sure there are favorable jurors, non-objectionable jurors. These are 2 different aims. Correct. One, it seems to me, is closer to a constitutional dimension because an unbiased jury is something I have a 7th Amendment right to in a civil trial or a 5th Amendment right to in a criminal trial. And the other is more gamesmanship. So here, Juror 16 says that the plaintiff has a strike against him, and yet the court denies the cause challenge. First of all, can you defend that decision?
What happened is the court, after that questioning took place, the court actually called this individual up to the bench and individually questioned the potential juror and asked, can you be fair if I tell you the law? Can you follow it? So that is something, if we're looking at, on the original review of it, it's an abuse of discretion standard. The trial judge had the ability to look at this person as he was answering the questions, saw the demeanor, saw the, tone of voice, heard the tone of voice, was able to say, you know what, I believe you when you say you can be fair. Even though you gave these answers earlier, now that I've questioned you in person, one-on-one, looking you in the eye, I believe you can be fair and deny the challenge.
And there was an individual colloquy of Juror 16 on that issue?
Yes.
Okay. So that goes to the sort of bias question. The thing about Juror 22 is, you're right, the record doesn't reflect anything about this, and we don't know whether Juror 22 is objectionable because Juror 22 is biased, or Juror 22 just, I don't know, wears the wrong color shirt or otherwise strikes counsel as not favorable. That seems to me to be a different consideration. And any practicing trial lawyer, I think if he's or she is being honest, will admit that someone will be completely unbiased and still, I don't want them on my jury for one reason or another. I don't think they're going to be serious in how they judge the evidence. I think they, have a particular view of the law. I mean, there are all sorts of different, considerations that peremptory challenges are capacious enough to handle. And the sort of devil's bargain we make is we limit the number of these things, and we don't get a record for why it is that the peremptory challenge was exercised. So I guess what I'm saying or asking you is, do you really want us to sort of undo all of that and say, well, actually, even for peremptories, there should be a record of why this person is objectionable to trial counsel?
No, Your Honor. I'm not asking for that at all. And that's why I was saying, if you apply the harmless error test to this issue, this might be a situation where someone has to use their third peremptory to do this, ask for another, and is denied. 99 times out of 100, it might be something where it ends up being harmful because they lacked that extra peremptory. This particular case, on these facts, the First District said, looking at how this played out, and because you used a challenge on this alternate, we know that person was objectionable to you. That would have been on you. That person would have been on your jury anyway. So this is just one of those fact patterns that the First District looked at, and that's why I was saying that Judge Tannenbaum made very clear that he said this was a unique situation, and I don't think it's creating any new law or applying anything differently. You have the preservation that occurred. You have this third challenge that had to be used on someone who arguably should have been stricken for cause. Was it a harmful error to deny an extra peremptory or to lose that extra peremptory? Not on these facts, because we know that the harm is that an objectionable juror would have been on your jury that otherwise wouldn't have been there. That happened anyway here, and it was going to happen regardless. So on these facts, the court applied the proper tests and applied this court's precedent. And
you can have 30 seconds to wrap up.
Okay. That is all, unless the court has any other questions. The only one other point that I did want to make is we know that peremptory it's been argued that it's a personal litigant right, and we know that's not true because if you have situations where, perhaps you have multiple defendants or multiple plaintiffs who have an identity of interest, they can be forced to share peremptories. Single plaintiff can have 3. 2 defendants, if you have a tortfeasor and a vicariously liable party, they can be forced to share 3. Even if they don't agree with each other on how to use them, they're forced to share. So I did want to make sure to point that out because it's been argued that this is such an important right for every litigant personally, and we already know that that's not the case either.
Thank you.
Mr. Chief Justice, and may it please the court, I'll spend a moment talking about the problem we see in the case law, and then I'll spend the bulk of my time giving you some options in terms of how we think you could address it. Under current law, Hill and Busby, the single best thing that can happen to a litigant with a losing trial case is for a trial judge to deny one of their cause challenges erroneously. At that point, the litigant is off to the races. They have to exhaust. They have to identify another juror that they would strike with an additional peremptory. It doesn't have to be a biased juror. It could be a favorable juror. And the result has been, as we've shown in our appendices, something like 250 reversals in cases where there was no indication at all that there was any harm or that bias tainted the outcome of the verdict. We think that there are 2 things that you could do about this. They're in the alternative. And Justice Sasso, you sort of established, I think, a baseline with your initial line of questioning with counsel on the other side. Everyone, I think, agrees that the initial harm of that cause denial is cured with the curative use of the peremptory. So that's where we start. What Hill does, the analytical move that Hill does, is it says, well, we can still locate a prejudice to the appellant because they were deprived of a peremptory strike. And here's our first position, and we think the sort of most elegant and simple way to resolve the case. That's just not true. There has been no deprivation of a peremptory strike in that circumstance. Mr. Seidler was allotted by rule 3 peremptory strikes. He used 3 peremptory strikes, and he used them in exactly the way that he saw fit. And in the federal system, Martinez-Salazar, the court said exactly that. You're entitled to use your peremptories however it is that you want. Obviously, one of the best and highest uses of a peremptory will be to remove a biased juror, the result of an erroneously denied cause challenge. But the idea that you are actually entitled to a 4th peremptory, which is effectively what Mr. Seidler is asking for, we don't think is supported by anything other than that bald assumption in Hill and Busby. So that's sort of, I think, a paradigm shift about the way you think about peremptories, the idea that you are somehow deprived of peremptory when you make a curative use. But it actually...
Let me ask you, under the federal law, if, in the scenario you described, if a cause challenge is erroneously denied, and the peremptory challenges that are available to the defense are used on other jurors, and so they don't take advantage of the opportunity to use the peremptory to cure that mistake. And then, you know, things don't go well in the trial, and can they still appeal on the denial of the cause challenge?
Yes, Justice Kennedy, my understanding is that federal law, this is Martinez-Salazar, would allow an appeal in that circumstance. We think that there's good and bad in the federal case law here. We think that part
That's
of it...
the bad part.
I got you. I think it's hard to conceive of a justification for that rule. Our appellate preservation rules from Schroeder actually make a lot of sense.
Sometimes you got to take the bad with the good.
I understand, but I think this is one where you could look and say our preservation rules make sense. If it's within the power of the litigant to cure the error, say by using one of their peremptory strikes, they should do it. In fact, that's part of why we think that peremptories exist in the first place. So I think that part of Florida law actually makes a lot of sense, and you should keep that part. The part that doesn't make sense is this notion from Hill that, well, you used your 3 peremptories, but in fact you only had 2. I mean, that's a fiction that I don't think makes sense.
Can you apply special? Sorry.
Go ahead.
Can you apply special to this case?
Yes, so that would be our second position. If you disagree with us on the paradigm shift we're asking you to make here, then you would have to apply the harmless error statute and cases like special, or in the criminal context, de Julio. And this is, I think, where Justice Lawson's concurring opinion comes in from Deviney. And there's one, I think, important analytical move that makes the whole thing work. And the Chief Justice, I think you asked some questions that went to this, but it's about the presumption in the eyes of the law that there's a fungibility of unbiased jurors. If you indulge that presumption, then it is not a difficult thing at all to find that there is harmless error in these circumstances, because all that's happened is there was an additional juror, unbiased by definition, because that person was not subject to a cause denial and no one's made that showing. So you have an unbiased juror who sat, and all the appellant wanted to do was replace that person with another unbiased juror. And we have cited in our briefs at least 3 Federal Court of Appeals decisions, including one from the 11th Circuit, that found that, yes, the replacement of one unbiased juror with another, there's no reason to believe that that would result in a different outcome. There are additional reasons, I think, in Florida law that you would want to indulge that presumption. Not long ago, this court decided a line of cases dealing with the Stand Your Ground law, Boston and Dennis, and that presumption underlies those cases as well. This court said in Boston that if a trial judge makes a mistake in applying the burden of proof at a Stand Your Ground hearing, that is cured when the defendant goes to trial and a jury rejects the self-defense claim. I think what's underlying that is the premise that the judicial fact finder, who was also an unbiased fact finder, would have made the same decision as the jury, an unbiased fact finder. So there's ample support for this idea. But at the end of the day, we think that it's sort of a more complex argument to apply the harmless error cases. I think the far simpler way is just to sort of shift the thinking on your right to 3 peremptories means. I think it's very elegant just to say Mr. Seidler got his 3 peremptories, and that's not altogether different from.
Let me ask you. I mean, I understand your objective, I think, but we're here in a civil case. There are arguably some differences. One being that on the civil side, there is no statutory right to the peremptories, correct? And I'm struggling with seeing how anything we do in this case would not kind of set aside what is going to happen in criminal cases, because that's not, I mean, I understand you're here arguing before us, but that's not really this case. That's a different case. So what am I missing?
Well, let me say a couple of things about that. I think as a a matter of principle, it's very hard to distinguish, as the concurring judge tried to do below, the civil and the criminal context. Even if I were to spot, Your Honor, the idea that there is a statute in one context and not a statute in the other, in fact, we think that premise is wrong. We think it's all a matter of rule. The fact that one right is a statutory right and the other is a rule-based right has never been your test for whether or not harmless error applies. You apply harmless error review to all sorts of even constitutional errors in criminal and civil cases alike. So I don't think that that can be the answer. The question really is just, is the right susceptible to harm review? That's what the court said in DiGiulio and Davis is the test for whether or not you apply structural error review or harm review. But the last thing I'll say is the paradigm shift we're asking the court to entertain about how you think about peremptory strikes and the value of them actually is not a concept that's foreign to Florida law. Our review of the history shows that in 1963, this court decided a case called Rollins. And in Rollins, the court effectively just adopted our view of the law. You can find that case at, I believe it's 148 Southern 2nd 274. And what Rollins did was it asked on appeal whether or not there was a basis for asking for the additional peremptory strike after the litigant had exhausted all and had pointed to a cause error. And the court said, I don't think that your reasons are very good for saying that the additional juror who sat was biased, and thus you were not entitled to any extra peremptory strikes. You got your allotment, and that's sort of it. That changed, of course, in 1985 with Hill, but we think that the sort of doctrinal moves that Hill made were clearly erroneous.
Does your position, though, create a per se rule in the opposite direction? For-cause challenge must be preserved. Now, for-cause challenge must be preserved with peremptory, and if you do, then there's no way to demonstrate harmful error.
I'm not prepared to say, Justice Sasso, that there would never be instances where a court could not reverse. Certainly, if a litigant exhausted all of their peremptories and then there was an erroneously denied cause challenge, that would be a very different circumstance, and I think in that circumstance you would have reversal. So, I think that's one way that a litigant could show reversible error, but on our second theory, the idea of juror fungibility would probably require affirmances in most cases.
Yeah, when would there ever, other than a cause challenge that you could support, when would there ever be a reason that it would be an abuse of discretion to deny a request for the extra peremptory?
Right, well, we think you would never be entitled to that extra peremptory, but I think most cases probably result in affirmances. There might be some case where someone could point to something that the juror that they thought was objectionable had said in jury selection that you might think.
If the judge said, no, I'd be inclined to give it to you, but you're wearing a blue tie instead of a red tie.
We think that gets almost over with you.
But short of some absurd thing like that, there'd be nothing.
Look, I must confess that I think in most circumstances, maybe all, the result will be an affirmance. But the opposite rule, we think, is proven to be fairly disastrous to judicial economy, to the justice system as a whole. And so we think that on balance, our approach gets you to a better place. Thank you.
Thank you.
May it please the court, I want to address three things if I have time. And one is this court's decision of Williams, which I think explains the difference in the sort of analysis when you're dealing with a jury composition issue. Judges are used to dealing with deciding whether the evidence that goes into the box creates harmless or harmful error by looking at the totality of the evidence. But what judges cannot do is decide what goes on behind the curtain in the box. And that's why in Williams, this court said we can't interview the jurors. There's no evidence that the alternate juror in Williams was biased or was objectionable. They were sitting on as an alternate. But the court said we can't, other than interviewing the jurors, we can't make a decision here. So therefore, that's the distinction here when you're dealing with a situation like this. You've got to recognize that we can't look inside the box. The second goes to the issue of special, and of course the fact that the decision below, in fact, a couple times specifically switches the burden of proof and puts it on us as we did not prove this situation. But I want to make sure it's clear that their idea was that, I think as Justice Curriel was saying, is that jurors 22 and 12 were equal, or they're fungible. That just simply can't be the case. And as a practical matter, just to be clear, and most of you picked juries or been on jury or judges in jury trials, you understand that sometimes you use a peremptory challenge because you don't like a juror, you think they're going to be bad for you, that you, as they say, you suspect but cannot prove they're biased. But with alternates especially, sometimes you just like that person next to them better, because if you don't, you get one strike for two. If you choose A or B, whichever you want. A might be juror 12 might have been an A- juror, a really good juror, but juror 12 might have been the dream juror. And an alternate, you're going to use that. So the idea that there's an objectionable juror sitting on this panel was simply pure speculation by Judge Tannenbaum, by the first DCA. Nobody can prove it, and when you can't prove it under special, the tie goes to the person who was hurt by the error, not the beneficiary of the error. They've got the burden of proving that. And finally, I want to sort of close with what the state was arguing, and I think that, Justice Kennedy, you hit the nail on the head. Why are we dealing with this issue in a criminal context? Why does the state have a say here? First of all, if all jurors are fungible, as the state suggests, as I think he did concede, it would essentially mean that this rule goes away. You're just going to affirm every case. You're not going to be able to have error as long as you have a peremptory you can use on that juror. But the state is asking for a paradigm shift, and what's odd about that is that the state is doing something that the respondent is not doing. In the civil case, and I think this is clear from Abota's own brief, nobody wants the law to change. Now, Marina Bay wants to win this case. I recognize that. They understand that there are ways they can win this case. But the plaintiff's bar, the defense bar, likes it the way it is. I don't think the trial courts are upset about this. And in fact, even though there may have been 200 plus reverses over 50 years, that's really not a crazy amount, as I pointed out in my reply brief. So for those reasons, we would ask the court to quash the first district opinion and to order Mr. Seidler a new trial. Thank you.
Thank you. Our last case today is number 210484, Florida Bar versus Schwartz.
May it please the court, my name is Chris Altenberg, and I'm here today representing the Florida Bar in Mr. Schwartz's 9th disciplinary proceeding. My argument today concerns only the appropriate sanction, so I'm hoping to save about 4 minutes to respond to the cross-review and to provide a reply. The Bar is challenging the referee's recommendation of a 90-day suspension, which was based on her assumption that Mr. Schwartz would also receive a 90-day suspension in his 7th disciplinary proceeding. Following the oral argument in that case, this court knows that you imposed a 3-year suspension instead. Over the last 20 years, Mr. Schwartz has been found to have intentionally violated Rule 4-8.4 9 times. In his 3rd disciplinary proceeding in 1997, he received a public reprimand after being held in indirect criminal contempt by the circuit court. In his 6th case in 2012, he received a 90-day non-rehabilitative suspension for filing several affidavits with improper notarizations, one of which he notarized with his own notary stamp, which was expired. In the 7th case, which is the case for which you recently gave the 3-year suspension, he inserted another man's face into a copy of the police photo lineup in the place where the victim had circled Mr. Schwartz's client. He did that with the hopes that the victim of that robbery, an armed robbery, would misidentify the man inserted instead of his client so that his client might be found not guilty. At least that man was dead. In this case, the represented person for whom he prepared and filed a Byrd affidavit, hoping to have that person admit that he was the one who was involved with the drugs in the kitchen area of this searched house, that he was the one that did those things rather than Mr. Schwartz's client. And Mr. Johnson, the man who was willing to admit these things for whatever reason, was still very much alive. And Mr. Johnson was clearly represented by the Office of the Public Defender, and quite obviously needed the legal guidance of his own attorney before he agreed to confess to crimes that he could have been subsequently prosecuted for. If a Byrd affidavit was to be filed in that case, it needed to be filed by Mr. Johnson's real lawyer to fulfill some objective of Mr. Johnson. It wasn't to be filed by Mr. Schwartz giving him advice to have his trial tried first when he was not his client. And Mr. Schwartz had multiple opportunities here in the following 6 weeks to figure out that he had violated Rule 4-4.2 and withdraw that affidavit. Instead, he continued down a path that repeatedly interfered with the administration of justice. First, he files a motion for a separate trial for Mr. Johnson. So Mr. Johnson's trial can be tried first, theoretically to waive a Fifth Amendment right. Now, Mr. Johnson was the man right inside the door when the police executed the search warrant. He had about a dozen baggies of cocaine in his pockets and $801. This was not going to be a difficult case for the prosecutors to prosecute. And he was eligible for career criminal sentencing. And yet, he was the one that Mr. Schwartz wanted to be tried first. I'm sure his lawyer would have agreed with that tactic. Then he attended the hearing on the motion that he had filed, and because of his recalcitrant actions at that hearing, the judge in frustration put Mr. Johnson on the stand, asked him a question, and you can almost hear the judge hearing himself trying to withdraw this question, but in the interim, Mr. Johnson makes statements that are at least his concession that he committed crimes that Mr. Schwartz's client had committed. Mr. Schwartz not only didn't immediately say, let's disregard that answer, shouldn't have been answered. No, instead, a week or 10 days later, he files a motion to have that evidence used at their joint trial so that he can tell the jury at their joint trial that Mr. Johnson's already admitted here on the stand in the same courtroom that he's the one who's responsible for the marijuana in the kitchen, not my client. There is no question that the filing of the Byrd affidavit, that strategy, interfered with the proper administration of justice because of the actions of Mr. Schwartz. For his prior misconduct, Mr. Schwartz has now received all of the available sanctions under the rules regulating the Florida bar, short of the sanction of disbarment with leave to reapply after 5 years. Any suspension that you might give would simply be in addition to the 3-year maximum sentence of suspension that he is already in the process of carrying out. Today, with this yet additional example of Mr. Schwartz intentionally seeking to win for his client at the expense of the rules designed to protect the legitimacy of our criminal process and to protect other people, it is time to disbar him. The standards, especially 6.1, 6.2, and 7.2, support disbarment here. I admit that in this case, like many other cases, there's no case square on point to aim to that says this is the one that says disbarment. But certainly in trying to decide whether disbarment would be an outlier, there are cases like Bitterman that demonstrate that when a lawyer has run through the pattern of misconduct through the gamut of all of his other disciplinary actions, it is time to seriously consider the 5-year version of disbarment. I think it's important for this court to understand in these cases that in this context, you're not being called upon to make a moral judgment of Mr. Schwartz. You're engaging in a rational decision-making process to reach a practical decision about between a 3-year suspension and a 5-year version of disbarment, which is the better approach to address this problem.
And also to consider the interests of the public.
That's right, yes. That's a part of the balance as well. And when you're doing that, first, admittedly, some of the older cases refer to a lawyer who's disbarred as being beyond redemption. And I've never argued that to you. I never will. I think
that's permanent disbarment.
And normally that's permanent disbarment. But even there, I will tell you, I don't believe one human being, just as a matter of faith, should be judging whether another human being is beyond redemption. That's not the test that I would make for you here or even in a permanent case. But instead, you're called upon to decide whether a particular lawyer is likely to succeed if rejoining the active bar and thereafter successfully assisting clients if he receives a 3-year sanction and you think that's sufficient for the public, and he gets the more expedited form of reinstatement, or whether you think that lawyer has demonstrated by his prior conduct and by what his demonstrated character of his content of his character, that he needs a longer period for rehabilitation, but he also needs to be fully vetted in the standard process that's used for application to become a licensed lawyer. That he needs that process not because it's a sanction or a penalty on him, but that's the process that gives you greater assurance that if he actually gets back into practice after 5 years, he won't do all this stuff all over again. He won't continue what he's been doing for the last 25 years. And I submit to you that if you review what Mr. Schwartz has done in all of these cases up until today, he fits the category that is the category for the 5-year version of disbarment. To protect the rule of law and the administration of justice, it is fair to the citizens of this state who depend upon our courts for peaceful resolution of their disputes with due process that he be disbarred in that fashion. It is going to be, I will hope, a deterrent to other lawyers that there comes a point in time when you're not entitled to yet one more disciplinary proceeding before you receive this sanction. And finally, I think it will be fair to Mr. Schwartz because it still leaves him with the opportunity, if he will put his ducks in a row and try hard, that he can get back into the bar and once again be an officer of the court. But today he needs that 5-year sanction. So unless there are any additional questions, I'll save the remainder of my time. Thank you.
Good morning, Your Honors. Ben Cuney. I represent Jonathan Schwartz, who is present as the court directed. And the issue before this court, serious, Mr. Schwartz has acknowledged the seriousness, is whether after this court directed the 3-year suspension in the prior case, we called it the lineup case, and the court is quite familiar with that. This case, traveling at the same time as that case, conduct that was tried when there was no discipline finding in that case, warrants the enhanced punishment of disbarment. We've suggested in the brief, argued in the brief, that the referee took full measure of this case, full measure of the gravity of the circumstances, recognized Mr. Schwartz's accomplishments as a lawyer and his failings in this case, and sought to impose a punishment that she believed at that time was to be concurrent, coextensive with what the prior punishment was, which was, as the court knows, altered by this court, a 90-day non-rehabilitation suspension. And the court did that in her sanctions recommendation, finding essentially that the conduct here a violation of the rules, we've cross-appealed on those findings, came at a time when the bar timed this case subsequent to the additional punishment, and it would have been appropriate to consider the two with one soluble resolution. And this court is asked, is it fair to the public to be protected, but also to have available the positive traits of a lawyer of nearly 40 years practicing exclusively criminal defense, running what the judge characterized as the private public defender's office, clients who were slightly not eligible for the public defender, but not eligible for substantial retention of counsel. What he's done for near 40 years, not a dispute on this record. And should that punishment be borne out with the 3-year suspension that Mr. Schwartz is following currently, and I'll mention what Mr. Schwartz, the record reflects, has been doing with his rehabilitation, and essentially be a concurrent suspension. That's what we believe this record reflects is the appropriate measure of punishment. Fair to the public, fair punishment for Mr. Schwartz, given the conduct and the timing, and without a doubt, a deterrence to lawyers, all lawyers, but lawyers who practice, and there's no excuse for misconduct in the criminal courts, just as there is not in the administrative or civil courts, but practice in the criminal courts day in and day out.
Mr. Cooney, what are we to make of our cases about cumulative misconduct? I return to the idea of protecting the public, and the record does reflect Mr. Schwartz's 40 years of law practice, but it also reflects that this is the 9th time that he's gotten into trouble with the bar. And while I understand the argument that you're making with respect to the most recent 2 violations, help me contextualize that in the preceding 7 and how, given the charge we have to protect the public, we can agree to another go-around here.
So first, Justice Coriel, the measure of punishment that Mr. Schwartz is asking the court to consider is not a slap on the wrist, nor is it a failure to acknowledge what the court found was a series of misconduct over the course of a lifetime of practice. Misconduct that really needs to be looked in 2 categories. One, and serious, advertising / dispute with your former associate's conduct, and then conduct that involves the court and judicial system. And with regard to the latter, all of which is important, all of which the precedent says you have to look at the lawyer's character, with regard to dealings with the judicial system, Mr. Schwartz, 1, acknowledged his misconduct. 2, in the process from the photo lineup case to this case to going forward, the referee found significant evidence of real rehabilitation, changes in practices, bringing in partner-level person to help deal with the thorny thicket of issues that come in this case.
When did that happen? When did he bring on partner level? Like, situate that for me chronologically. Did that prevent any of the violations now before us?
Your Honor, in connection with the timeline is in connection with the bar proceedings in the lineup case. Mr. Schwartz changed his law firm and brought in a partner level person. It was after the line.
Counsel, I don't understand how that has anything to do with the deceptive conduct that was involved in the lineup case. That's not about not having a partner. That's about doing something deceptive, something that on its face is deceptive. That's basically what we decided.
Absolutely.
And so
Judge.
I don't understand how that remediates that. I mean, maybe it's, if it's a minor to not let you do anything wrong, but I'm puzzled by
Yes,
that
Justice Kennedy.
suggestion.
And
And
this-
I'm further puzzled that, we've got this, and all this stuff a lot of this is going on over an extended period of time. But, if this had been before us in the lineup case, we gave 3 years for what was before us there. This is another serious matter. I think you look at cases where we get these multiple offenses that are even of a different character. I'd look at that. You'd think we might have given in that proceeding might have given disbarment. And I don't know if it's part of the record here, but I know it's a matter of public record that we've got 2 more cases coming our way. Now, obviously, we put that aside, but whether this all should be resolved, all the discipline here should be even resolved until we deal with those cases, I think that's a question the court would have to consider, because they keep coming.
Justice Kennedy, 2 points in response. First, agreeing with the court that in the lineup case, the court made very clear what the law was, Mr. Schwartz's transgressions. We know what the record is, and this court made very clear, despite Mr. Schwartz's belief in what the law allowed, his conduct was deceptive. I'd say deceptive at law. No excuse, and Mr. Schwartz offers no excuse whatsoever. This conduct, and this goes to your question, why would it even matter what reformative conduct Mr. Schwartz engaged in? The ability to talk through prickly, thorny issues, and I respect that the court will decide if something is prickly or thorny, but the morass of issues that criminal defense lawyers go through every day warrants the collegial discussion that this court has. Mr. Schwartz recognized that, brought in a partner-level person for exactly that give and take. Has it been perfect? No. The record reflects, and the referee was very motivated by Mr. Schwartz's therapeutic work. And basically that we disagree, and the judge made clear it was not a win-it-all philosophy, but an overarching helping philosophy. How do I turn that into a positive? And the judge, the referee, found there has been substantial success there. Putting to the side whether there is any rational justification for what Mr. Schwartz did, and as you know, we've contested the findings of clear and convincing evidence that Mr. Schwartz believed he followed the narrow, non-harmful, minimal conduct that he believed was allowed by this court's precedent and the rule, and the referee found imperfect belief, did not find bad faith, but found that it was improper conduct. We believe that this court needs to be very strong and very clear that the referee, in attempting to measure this punishment with the then pending punishment, should warrant a 3-year suspension, that Mr. Schwartz follows through, continues with his rehabilitation. And yes, it is difficult to describe 2 pending cases that haven't been fully fleshed out. I do not ask the court to hold this case until those cases are resolved, because I do not know what that timing is going to be. But
It can
certainly
only get worse. I mean, how is just giving a concurrent, and I really appreciate your demeanor and professionalism, by the way, but how is it a deterrent or a punishment to just do something concurrent with what Mr. Schwartz is already subject to.
So, Mr. Chief Justice, I would posit this. Had Mr. Schwartz, hypothetical, had Mr. Schwartz been subject to a finding that he exercised his knowledge wrong in the lineup case, and yes, we know it was highly improper, and certainly every criminal defense lawyer has now been through FACDL seminars at which Mr. Schwartz was one of the, not featured speakers, but one of the participants to explain the perils of that process. We recognize that misidentification is a clear issue in criminal defense cases. But had that been in existence and Mr. Schwartz engaged in this kind of conduct, Your Honor's question is spot on. But despite this court's ruling, after the fact, Mr. Schwartz presented his position in the photo lineup case, and the referee had found that he was not culpable. He did make corrective actions in his practice from that time, but it's not anywhere similar to the repeating misconduct of cases where lawyers, having been sanctioned, do the same thing and the same thing. And I believe the record is clear why the referee decided in the nature of a concurrent resolution, noting that, frankly, had the cases been brought in a more timely manner, they might have been, as Justice Kennedy pointed out, riding along at the same time. They might have been resolved at the same time, not one before the other. And the referee was quite clear about that. I also want the court to recognize that
the referee did not have the benefit of our determination that a 3-year suspension should be imposed.
Absolutely, Justice.
A report came out shortly before our opinion issued. Isn't that correct?
Yes, Justice. And the referee was aware of that, knew the case was pending, knew what the then existing punishment was, because that's all the referee had, and tried to measure this conduct with that measure of punishment. And from an analytical point of view, I suggest that is what the referee would have done, and appropriately would have done, had the timing been slightly different. The referee took all of that into context with the work, what happened here, as the referee said, a misperception of the Decker rule, not intentional, and made the fact finding, although it was prejudicial to the administration of justice, it affected the criminal justice system. There was no actual harm or likely harm to the participants. On the merits of the cross appeal, I would like the court to revisit the briefs and note that with regard to the communication issue, Mr. Schwartz acted in a good faith manner, believing he walked that narrow line of having no substantive communication with the co-defendant, best friend of his client, but yet was able to pursue the constitutionally effective potential severance without...
Something he could have pursued by talking to his counsel, right?
No doubt, Justice Curiel.
It doesn't seem like a terribly narrow walk he was effectuating.
Oh, it was a significant walk. What was the not narrow thing is picking up the phone and demanding to speak to the public defender when Mr. Johnson said don't, and gave ambiguous, in retrospect, comments about not being represented by the public defender. What Mr. Johnson meant was he has no idea who his lawyer is because every time he shows up, somebody new keeps popping up. And Mr. Schwartz understood that to be, let me take the least amount of action to preserve all the issues, not cause any jeopardy for anyone, and have Mr. Johnson do what Mr. Johnson wanted to do after Mr. Johnson said, I'm not calling the lawyer, when Mr. Schwartz said. Obviously, we know and there has been testimony in the record, referenced by the referee, criminal defense lawyers deal with these issues all the time.
Sir, I'm sorry to interrupt you. You can have 30 seconds.
Yes, Your Honor. In closing, the real practical effort Mr. Schwartz has made over his imperfect near 40-year career to advance the system of justice, to try to do and learn from his, to try to do right and learn from his mistakes. His current service of a 3-year suspension that was not known at the time of this discipline warrants this court to treat this as appropriate for a concurrent suspension if the court finds that the evidence of the communication was sufficiently clear and convincing. In the brief, we've suggested, we've argued it's not, and would ask the court to revisit that finding. But on the sanctions, we believe that a sanction of 3 years concurrent suspension is appropriate. Thank you, Justices.
Thank you.
You've had a long morning, and unless you have any questions on the cross review, I don't think I heard anything that causes me to need to argue the cross review to you.
And I'm sorry, I'm sure you said this in your papers, but I can't remember. Is your request that the 5-year disbarment start now or at the end of the 3-year suspension?
What I did was recognize that you all have the authority, if you choose to do so, to run it from the earlier date, that you could run the 5 years from when the 3 years started 18 months ago or so. I'm not quite sure where that is. Or you can begin to run it now. Often you begin to run it now, but the bar took no position as to what you should do on that. And the only other thing I would say on the penalty aspect of this is that, you know, I think that Justice Kennedy is correct that if you had these cases packed up together, including the one pending case that's actually ready for resolution now, which is 19-983, that the 3 of those cases together 2 years ago unquestionably would have caused this court to jump automatically to the 5-year form of disbarment, even though he had not had a non-rehabilitative suspension at that time. I was not advocating for disbarment last time because he'd never had a rehabilitative suspension, and I felt that step was necessary, that he'd be given that one last chance. Frankly, I didn't realize I'd be back here quite so soon. But at this point in time, I think the 5-year the disbarment with leave to reapply in 5 years is the appropriate sanction. Thank you.
Thank you very much. And that's it for today.
All rise.